Live. Everywhere. On netrootsradio.com. David Waldman. Kagro. In the morning. Now, here's David Waldman.
Hey, good morning, everybody. How you doing? It is, for our purposes today, Friday, January 31st, last day of January 2025. Time for another show. Not that I am there to do it for you, but I am here. Does this make any sense to you? I am here. I was there. I guess time travel once again. I was there yesterday, and now you're hearing me be there yesterday. Currently. How do you like that? Does that make any sense to you? There were so many things that we didn't get to yesterday because there was, of course, the tragic air crash story to cover. And, of course, by now you will also have seen that Donald Trump spent Thursday afternoon taking the microphone to blame DEI for the crash, as I guess we all knew he would. I mean, it certainly instantly occurred to me. I spent most of last night thinking, he'll in the morning, he'll stride to the microphone and say DEI caused this crash, or Biden caused this crash, or both. And, you know, there was some part of me that thought, he's not that ridiculous. Not when the bodies still haven't been recovered yet. But there he goes. And by the way, this is the sort of thing that used to embarrass or disgust Heartland MAGA types. Yes, even MAGA types, who undoubtedly would have at least spent the bulk of the first day saying, well, bless their souls. My prayers go out to their families. And Donald Trump just immediately effed the souls. There's points to be had here. And if I don't attack, someone will try to blame me for it. And I know that there were certainly people that were doing that. And you know what? I'm beyond like distancing myself from that or disavowing that. Instinctively, internally, do I think that there was anything that Donald Trump did that really led to that crash? No. Was it wise to gut the FAA? No. Did the effects of his attempting to gut the FAA really have anything to do with it? I don't think so. But you know, it's like, why forbear on this stuff when you know that in the morning, you know, you're going to have spent the evening being careful and wringing your hands about things because, we described it, what would be yesterday for you, as just sort of par for the course for technocratic or, what was the other term we used? Technocratic or, dang, I've already forgotten. But technocratic politics or the various identitarian politics. I've already forgotten what our chart said, although that was fascinating. Oh, yes, pluralist politics. That's it. But we would have been out there wringing our hands saying, well, what really caused it? Let's find the cause. Because as technocrats, and this is the reason why air travel has been so safe for so long, is that, and why people would get back on a plane even after an incident like this. You know, years and years ago, when we didn't have as much data and do as much study and have as much regulation for safety as a result, people did. I'm sure people will worry about getting on planes now, just, you know, out of general fear. But people kept traveling on planes because it was safe. We haven't had an accident like that for years and years and years. You might point out, you know, well, those are the years during which we've allegedly been doing all this crazy DEI stuff and there's been no accidents. And as soon as Trump gets into office, it's too soon for this to have happened. Yes. But as soon as Trump got in office, he supposedly repealed all of that. He specifically said, we're going to get rid of the DEI stuff, even at the FAA. And of course he didn't. But if you took him at his word that, yeah, the executive order says I ended DEI at the FAA, well, then it's gone. And then immediately there's a crash. So maybe you have the cause backwards, but we really don't, of course. But this is the sort of thing that ordinarily used to disgust heartland Americans, but we don't play that game anymore. We're now in friend-enemy politics. It doesn't look like it's going particularly well. That's for sure. But again, you know, reporters just being a little bit too cautious and playing the technocratic role here because they're not into identity politics, or whatever. So they're asking, I noticed one asking the question, a video clip being circulated of Trump having just blamed DEI somehow for the crash. And all he did was say, maybe it's a DEI thing, essentially. And somebody said, well, you're saying it was the DEI that had something to do with this crash. It could have. But right. Well, this is not sports talk radio call-in show. This is a presidential news conference. You can't do that. But he does. There's no such thing as can't anymore. And then a follow-up question later on, a reporter says, well, now you said that DEI could have had something to do with it, but then yet you also say that this is still under investigation. Like, how can he says, I'm trying to figure out how you can say it's still under investigation, but then come out here with this conclusion that it's DEI. I'm trying to understand. He says, and Trump's answer to that is because I have common sense. Okay. And, that's honestly, that was the answer. And I'm just looking at this reporter saying, I'm trying to figure out, like, you're not trying to figure it out. I think you've sniffed it out here. Your question is, well, how can you possibly? Because you know that you can't possibly. Trump is bullshitting here, and you should just say so. And your real worry is that you're going to have to go back and argue with your editor about whether or not you're going to be allowed to say that. And you should have that argument, and you should stand up for yourself. And if you don't want to use the word, find another one. But I mean, there's nothing there. There's no reason in the world why he should be allowed to get away with saying that. And you're not trying to figure it out. You know the answer. You're trying to get him to change his mind and say he was wrong, and he's not going to do that. So just do your job at this point. I don't know who the reporter was, but maybe I can grab those clips for you and I'll pass them along to you. And you can try and do your own evaluation of it. Okay, what I really meant to do today is get to a couple of stories that really didn't have anything to do with the breaking news of the day. Very hard to avoid. And I'm sure by now, by now things have gone a lot crazier than they were, at that other weird point in time at which I recorded this show, which is now. Anyway, like I said, a couple of other stories that just didn't make it into rotation yesterday, but should have. One, a growing body of evidence that January 6th rioters who were pardoned by Trump are hardcore recidivist criminals. NPR, of all places, has a collection of such stories, and I don't know if it's even comprehensive at this point, but we'll see what they have to say and whether we have anything to add to it. This by Tom Dreisbach, I'm guessing is the pronunciation here again, at NPR, and they've got the recording of it, but I'm going to read you the write-up. Criminal records of January 6th rioters pardoned by Trump include rape and domestic violence. Isn't that something? We're all very surprised by that. And, well, interesting. There's an editor's note right up at the top that says, this story includes descriptions of violent crimes and sexual abuse involving both adults and children that may be disturbing to readers. In this case, disturbing to listeners. I'll just simply plug my ears and read right through it. Although you've heard me read stories in the past and heard me take a pause and say, I'm not sure this belongs on the air. See what happens here. Let's all be surprised together. On his first day in office, President Donald Trump granted clemency to every person charged or convicted for their role in the January 6, 2021 attack on the U.S. Capitol, even those convicted of violently assaulting police officers. But Trump's pardons and commutations for people he has called patriots does not wipe away certain defendants' extensive criminal records or any other criminal charges they may be facing. Let me just caution you, not so fast. You think that's the answer because that's logical and that's the way the law applies. But you're living in friend-enemy territory now. And that's not the way things work anymore. And this may be better explained by gimmitarianism to the extent that it differs from friend-enemy politics. Anyway, While many people had no criminal record prior to committing crimes on January 6th, NPR has identified dozens of defendants with prior convictions or pending charges for crimes including rape, sexual abuse of a minor, domestic violence, manslaughter, production of child sexual abuse material, and drug trafficking. They're all bad. One of those defendants, Matthew Huttle, Huttle. And this was a story that came up the other day, and I regret that I didn't blurt it out right away. And I think I did it like at the end of the show. Hey, this happened. But I didn't get to tell you about it. Here's the story. Matthew Huttle, recently shot and killed by law enforcement in Indiana during a traffic stop just days after receiving a pardon for his role in the Capitol riot. I think I remarked at the time that you can't get, well, one person did, but this guy didn't, get himself shot storming the Capitol, trying to overthrow the government. But a traffic stop in Indiana turns out to be a lot, well, it's deadlier than an insurrection, which is kind of amazing. In 2023, Huttle pleaded guilty to entering and remaining in a restricted building or grounds on January 6th and received a sentence of 6 months in prison. Huttle, quote, has an extensive criminal history that demonstrates a pattern and practice of disrespecting and disobeying the rule of law, which is consistent with his actions on January 6th, 2021, the prosecutors said. In one incident, Huttle spanked his 3-year-old son so hard that he left bruises all over the child's backside and the child's neck, and the child had such extreme pain on his backside that he could not sit properly for a week, prosecutors said. Huttle was sentenced to 2.5 years of imprisonment for that abuse. Prosecutors also noted repeated arrests for driving under the influence of alcohol. Huttle's defense attorney attributed his criminal record to a history of, quote, extreme alcohol abuse. By the way, that's not going to get you off the hook for a DUI, is it? Even after January 6th, Huttle continued to rack up state charges in Indiana for driving offenses. Less than a week after he received a pardon from Trump, Huttle was fatally shot in an altercation with a sheriff's deputy, according to Indiana State Police. Well, that's the end of the summary of that story about Huttle, but we move on to Trump's argument for blanket clemency on January 6th. Trump has defended his decision to give pardons and commutations to all of the defendants charged in connection with the violent January 6th attack by suggesting that evaluating all of the cases individually would have been too difficult. Not that he was going to do it, obviously, but I guess his favored aides are able to plead laziness, and he says, yeah, you're right, why should anybody work? It would be very, very cumbersome. Oh, this is Trump. It would be very, very cumbersome to go and look. You know how many people we're talking about? 1,500. I don't know whether he said 1,500, but it's printed as 1,500 people. Trump told Fox News earlier this month. He also said that the prison sentences for January 6th defendants were excessive. These people have served horribly a long time, he said in his Fox News interview. This, again, overlooks the fact that a lot of them never actually served their time because their cases were still pending. Trump's comments overlooked the role that the January 6th defendants' prior criminal records played in sentencing. And that's another reason why, why were they treated so horribly? Their sentences were so long because they were repeat offenders. And the judges did what you say you would do in getting tough on crime. You keep being dragged in here by police time after time after time. Well, we're going to make you pay. Well, no, we're not, because the last crime was patriotic, I guess. Trump's comments overlooked the role that the January 6th defendants' prior criminal records played in sentencing. Federal judges take that criminal history into account when deciding a criminal defendant's sentence, as Trump would have you do, no doubt, if the defendant is on the other end of the friend-enemy political spectrum, of course. But, and this really illustrates the simplicity and stupidity of the friend-enemy construction, right? This is why everybody has such tremendous difficulty with his hypocrisy. But again, if you're playing the technocratic or pluralist game where the law is applied equally to all comers, it's hypocrisy to say people who assault officers of the law should be executed. And then you find people who have assaulted officers of the law, and you're pardoning them. Why? Because the other people who assaulted officers who should be executed are enemy camp. And the ones who assaulted the police officers on January 6th are in the friend camp. It's not hypocrisy. It's 100% consistent with the lizard brain, inhuman bastard way of looking at things in the world. By the way, Darwin straightening things out for me after the show, or I saw it after the show yesterday, sending me a blue sky note saying, I could have saved you, a half an hour of discussing this chart. It's nerds versus lizard brains. Yes, in many ways, it does boil down to that. And of course, what's more technocratic and nerdy than explaining for half an hour that, well, it's nerds versus lizard brains. But let me tell you about all the nuance of it. Although I do think it's a little bit more than that, but not that much. I mean, he's really onto something there. That does save some time. And well, if you missed the explanation yesterday, then you're fine with going with nerd versus lizard brain. That will do the trick. So anyway, in his mind, it's not hypocrisy at all. He's not playing technocratic politics where the law applies equally to everyone. What applies equally to everyone is you fall on my friend-enemy spectrum. And it can change at a moment's notice, but it's up to me. I decide if you're a friend or an enemy. So even if you were a friend before, Mike Pompeo, and now you're an enemy, no more security detail for you. That's all that, that's me being consistent. Now you're an enemy. You weren't before. That hasn't been consistent, but that it's up to me is consistent. Easy. A spokesperson for the White House, to return to this story, did not respond to messages seeking comment for this story. If Trump had looked at individual cases, the long criminal records of some January 6th defendants may have raised some red flags. Theodore Middendorf was accused by Illinois prosecutors of, quote, predatory criminal sexual assault of a child. That's some quote. Prosecutor said in a court filing obtained by NPR that Middendorf committed an act of sexual penetration. Well, I think we can all figure out what that act was about. There are limited options, let's say, no matter what happened here. Indiana state records indicate that Middendorf's victim was 7 years old. Pardon. That's Donald Trump. Donald Trump hearts child molesters. This is not the only one, by the way, among those pardoned in January 6th who were guilty of child sexual abuse. Middendorf entered a guilty plea in that case. Guess he figured they got me dead to rights in May of 2024 and was sentenced to 19 years in prison. He is currently registered as a sex offender in the state and remains in custody on those charges. But for how long? No, seriously, for how long? We'll get to that in a minute. Separately, Middendorf pleaded guilty to destruction of government property for striking a window at the U.S. Capitol with a flagpole on January 6th. He had not yet been sentenced for his role in the Capitol riot when the Justice Department moved to dismiss his case following Trump's order. Oh, they've been so poorly treated. They've been in prison this whole time. He wasn't anywhere near prison for January 6th. Should be, because he's a child sexual abuser, but he wasn't. Peter Schwartz had a jaw-dropping criminal history of 38 prior convictions going back to 1991 when he, see if anyone want to guess, assaulted police officers with pepper spray on January 6th, according to federal prosecutors. When those prosecutors made their sentencing recommendations to the judge, they described a 1994 disorderly conduct case for throwing a lit cigarette at a victim and striking her near her eyes, a 2004 case for assault with a deadly weapon, a 2019 case for terroristic threats for threatening, you'll never guess, police while under arrest for domestic assault, and a 2020 case of assaulting his wife, including by biting her on the forehead and punching her multiple times. Given that history, prosecutors said, the only reliable method of protecting the community from Schwartz in the future is to remove him from the community for as long as possible. Oh, he's so badly treated. Federal Judge Amit Mehta gave Schwartz one of the toughest prison sentences stemming from the Capitol riot, more than 14 years. Less than 4 years after Schwartz's arrest, Trump's pardon freed him from prison. Now, here's some other stuff here. Criminal cases unrelated to January 6th are ongoing. For now, Trump's pardons apply only, and I say you think, because that's the way it usually works, apply only to people, quote, convicted of offenses related to events that occurred at or near the United States Capitol on January 6, 2021. And that may even be from the pardon language. But LOL, YOLO, nothing matters. We'll get to it. I'm teasing it, but we'll get to it. As a result, some January 6 defendants are still facing criminal charges from other alleged incidents. David Daniel of Mint Hill, North Carolina, is charged with production of child pornography. Not possession, production of child pornography. And, of course, possession of child pornography, that which he had produced and who knows what else, which allegedly involved a prepubescent minor and a child under 12 years old. The government's forecast of evidence is compelling and suggests defendant engaged in sexual acts with 2 young girls in his own family. Magistrate Judge David Kessler wrote of the case against Daniel, and it's frequently the case with these abusers that it is someone in their own family. Shouldn't be surprised by that. It should be evidence of the likelihood of it having happened. Anyway, it is also alleged that he took and kept photos of the genitalia of the victims. The mother of one victim, the defendant's ex-wife, appeared in court to request that defendant not be released. Because of those findings, Judge Kessler ordered Daniel to remain in detention pending trial. Daniel has pleaded not guilty to the charges in North Carolina, and that case remains pending. Separately, Daniel pleaded guilty to a charge of assaulting police officers on January 6th, but he has not yet been sentenced. Trump's Department of Justice has dismissed that case. Oh, he spent so long in jail. He's treated so poorly for a patriot. He spent no time in jail. What are you talking about? He is not the only defendant facing ongoing criminal charges. Arrest warrant records allege that Daniel Ball of Florida threw an, quote, explosive device that detonated upon at least 25 officers. I didn't hear about this one, I don't think, during the Capitol riot, and also forcefully shoved police trying to protect the building. Now, an explosive device, I suppose, evokes a bomb, obviously, or a hand grenade or something like that. But, was it a firecracker? Probably, maybe. I don't know. You shouldn't be throwing it at cops. I think that's obvious. But, a more deadly device we would have heard about. And the fact that we didn't hear about 25 officers killed by an explosive device at the Capitol riot leads me to believe it was one of the less dangerous types, but who knows what can happen. And remember, you weren't supposed to be there, and you're never supposed to do that. Anyway, according to charging documents, Ball had a criminal record before his arrest for January 6th, including domestic violence, battery by strangulation. That's oddly specific. Resisting law enforcement with violence. Oh no, not that. And battery on law enforcement officer. How come this keeps happening? When federal agents arrested Ball on January 6th charges, they discovered that he was also in possession of a gun and ammunition, which was illegal given his criminal history, according to prosecutors. How odd is that? In addition to the January 6th charges, a grand jury in Florida handed down a separate indictment against Ball in August of 2024 for possession of a firearm or ammunition by a convicted felon. Ball pleaded not guilty to his Capitol riot charges, and the Department of Justice, following Trump's order, dismissed the case. No jail time. But Trump's pardon did not resolve his gun case. We think. On January 22nd, Ball was rearrested on the Florida gun charges. That case remains pending, and Ball has pleaded not guilty. Andrew, what is this? Taki? Taake. How do you suppose they pronounce that in Texas? Andrew Take, let's say, of Texas, pleaded guilty to assaulting police officers with bear spray and a metal whip on January 6th. No weapons, and was sentenced to 6 years in prison. He also had a prior criminal case that remains unresolved. The Harris County District Attorney of Texas said that Take was wanted on 2016 charges of soliciting a minor online. Of course, why not? We are already in the process of tracking Take down. District Attorney Sean Tear, it's Tear with an E on the end, Tear, I don't know, said in a statement shared with NPR, Take allegedly sent sexually explicit messages to someone he thought was a 15-year-old girl, and that's not helpful. Oh, I thought it was a 15-year-old girl, not a cop. But you know what? You're not supposed to send them to 15-year-old girls. That's why you're under arrest. So yes, in fact, it was an undercover law enforcement officer. Prosecutors allege this, by the way, as part of his January 6th case to get him sentenced properly. Here are some other January 6th cases where the defendant had a significant criminal record before they were charged for their role in the riot. They all received pardons from Trump. There is the case of Casey Hopkins, spelled with a K. Not Hopkins, that is obviously spelled with a K. Casey, Kasey, has a lengthy and troubling criminal history, including a 2002 conviction for forcible rape. In case anybody thinks there, any Republicans out there are not certain whether it's real rape or legitimate rape. This is the forcible kind, the legitimate thing, which resulted in a 7-year prison sentence. Not nearly enough. But anyway, this according to prosecutor's sentencing memorandum for his January 6th case. The defendant had forcible intercourse with the victim, choked her to the point of impairing her vision, banged her head into a wall, and, there's more, and did something else to humiliate her, and goodness, well, I knew there would be something that we eventually said, we don't really need to read about that one. But you can imagine it is degrading and humiliating and, I suppose, for him, sexual in nature. Prosecutors alleged in the arguments over sentencing. When the victim attempted to flee naked, the defendant caught up to her and threw her down. Prosecutors alleged that Hopkins also had other prior convictions for assault on a law enforcement officer. I can't believe it. Not again. Operating a motor vehicle without a license, possession of a controlled substance, on and on. In 2022, Hopkins pleaded guilty to the charge of parading, demonstrating, and picketing in a Capitol building and was sentenced to 4 months in prison. Prosecutors said that prior to the January 6th riot, he discussed the possibility of a civil war and proposed forming a group called Proud Felons for Trump. Why is he voting, right? I thought the guy he wanted to vote for said that felons shouldn't be allowed to vote. Anyway, it's not hypocrisy, it's friend-enemy, as you know. Pretty interesting, too, by the way, that a guy who's like, I pretty much do what I want to do. I rape people, I assault law enforcement officers, I drive without a license, I possess controlled substances without any regard for the law whatsoever. And then he's like, we're losing our country. The president says we're losing. I better show up because of how patriotic I am, to reinforce law and order. It's what an amazing thing to riot for. I'm a patriot. I just want to stand the government back up on its own 2 feet so they can keep arresting me. What? I mean, there really is an argument there for that. Everybody there was involved in criminal activity. I know some of you say, because you think it'll help you, that you thought you were patriots, but you were really looking for a get-out-of-jail-free card from the king of the get-out-of-jail-free guys. Hopkins wrote a letter to Judge Tanya Chutkin, who oversaw his January 6th case. How do you like that? Noting that, quote, "Ma'am, you have my rap sheet, and to my shame, it's not a good one," he wrote. "For that matter, I'm not sure if any rap sheet is good." He said prison had changed him for the better, and he expressed shame and regret for his actions on January 6th. He was well coached. Next up is USA versus Edward Richmond Jr. Everybody's photograph here, a lot of them from January 6th are here, and he looks among the more ridiculous. Makeshift armor, goggles, everything. He knew he was coming for combat. Also wearing some body cams, I guess, and radios and the whole works. He's in tactical gear and camouflage, which helps a lot when you're talking about white marble as your background. Anyway, in 2004, Edward Richmond Jr. was serving in the U.S. Army when he was convicted of manslaughter after shooting a handcuffed Iraqi cowherder in the head with his rifle, prosecutors said. Great, war criminal. For the manslaughter conviction, Richmond was sentenced up to 3 years of military confinement and dishonorably discharged. Patriot who's dishonorably discharged, you know. Richmond's criminal record, court documents indicate, also included convictions for resisting officers and driving under the influence, as well as an arrest for domestic abuse. For his role in a January 6th attack, Richmond pleaded guilty to the charge of assaulting, resisting, or impeding certain officers using a dangerous weapon. According to his statement of offense, Richmond agreed as part of his plea that he wore tactical gear to the Capitol on January 6th, including a helmet, goggles, and a camouflage vest. He stayed at the front of the mob fighting against police for almost 2 hours, the statement said, and struck officers with a baton. Richmond was sentenced to more than 4 years in prison for his January 6th case. There's more. But I kind of want to move along for the, you know, you'll see where I'm going with all this. I've been teasing this other story, but there's a Jonathan Gennaro Mellis, previous criminal convictions for drug trafficking, conspiracy to manufacture or sell methamphetamine, which resulted in a 20-year prison sentence. Prosecutors said he's also had a history of arrests which did not result in conviction, including for domestic assault. Once again, also picked up for January 6th crimes, including his use of a large wooden stick to repeatedly strike or stab police officers on January 6th. There's the case of Benjamin Martin, pled to obstruction of a police officer in 2003, 2016 battery charge where he repeatedly struck his 14-year-old daughter, 2018 battery charges, choked his girlfriend, dragged her back into the house after she tried to flee. One of these guys. Edward Hemingway, serious criminal history dating back to 2004, apparently, including sexual battery and criminal confinement. Criminal confinement. His probation was revoked. And he was resentenced to 5 years imprisonment after an initial bargain, I guess, and also picked up on January 6th charges. Again, I wanted to just skip over some of the details, but you should read them. They're shocking enough all by themselves. But what was I hinting at all this time? Do you remember that I told you about the story of, what was this guy's name? Well, let me find his case here. And then we'll be on our way. Oh, is it hidden behind one of these blue sky posts? All right. But I told you about the January 6th defendant who also had spent no time in prison, despite the claims from Donald Trump that they were so poorly treated and they spent so much time and it's so terrible and we got to let them go. He was released pending trial, as many of them were. Edward Kelly. Remember him? Edward Kelly released pending trial, and while he was on release, plotted with a friend of his to murder the FBI agents who were working the case that he was awaiting trial for. Well, we were wondering, A, whether he got a pardon, and of course the answer is yes, he did. Got a pardon, certainly for his January 6th activities. But are we going to also pardon the pending charges of his plot to murder the FBI agents that were pressing the charges against him the first time? And NPR, no doubt, concludes, no, that's not even to be contemplated. The terms of the pardon document leave it in no uncertain terms that you're being pardoned for your activities and crimes growing out of the activity at the Capitol on January 6th. Well, one, do we really know that? And two, what kind of argument can you make? Is there any that you could make that says this plot to murder the FBI agents grows from the activities at the Capitol on January 6th? If I hadn't been arrested for my activity on January 6th, I would have no FBI agents to murder. He's actually doing it, folks. And K-Funk 937, I'm going to call out everybody's crazy names here, forwarded this to me. I don't know whether you're a listener to the show or maybe just saw my comments about it on social media over the last couple of days, that wondering, would this charge be pardoned too? Well, guess what? Kyle Cheney reports that Edward Kelly, a January 6th defendant, says President Trump's order to dismiss cases should also cover his conviction in Tennessee for conspiracy to murder the FBI agents who investigated him. Curious to see how DOJ responds to this one. And so am I. By the way, along the way, Maurice T. Cunningham responding to this, my redistribution of K-Funk's notice here. He was only committing a crime in furtherance of another crime defense. Very effective. Here are two screenshots, only one of which is actually in focus, that Kyle Cheney included from, I guess, is this from Kelly's motion? It must be. Let's see if we can't find the source here. This is Memorandum of Law in Support of Motion by Defendant Edward Kelly to vacate conviction and dismiss indictment with prejudice. Of course, a 9-page document, but Kyle grabs two pieces here. We'll try and read them, even though one of them is out of focus. Indictment in the Eastern District of Tennessee is the subject, this portion of this pleading in which he's describing what charges he's facing. While the Washington, D.C. case was pending, that is the January 6th case, direct January 6th case, Kelly was indicted in this court here in the Eastern District of Tennessee on December 21st, 2022 on 3 counts. Count 1 charged Kelly and co-defendant Austin Carter with conspiracy to murder employees of the United States in violation of 18 U.S. Code Section 1117. The indictment alleged several overt acts in furtherance of the conspiracy, including on or about December 13th, 2022, Carter provided the CW, cooperating witness, with a list of FBI employees that Carter received from Kelly. Count 2 charged Kelly with the solicitation to commit a crime of violence in violation of 18 U.S. Code Section 373. And count 3 charged Kelly with influencing a federal official by threat in violation of 18 U.S. Code Section 115A1B. Kelly proceeded to a jury trial on November 18th through the 20th, 2024. On November 20th, he was found guilty on all 3 counts. His sentencing hearing is scheduled for May 7th, 2025. It takes a while to get around to these things. And then the argument. This clip reads, the incidents giving rise to this case occurred while Kelly was on pretrial release in the D.C. case. While he was on release, and not in prison, while he was on release, a snitch named Christopher Roddy, and remember they're using the term snitch. If you're taken aback by that, remember that this is the defendant's pleading. This is the way the defendant's lawyers agreed to describe the informant. A snitch named Christopher Roddy contacted officers about a list that he had received that originated with Kelly, targeting the FBI and various other law enforcement agencies. The only reason Kelly was able to draft a list, this is amazing, was due to a mistake in the U.S. Attorney's Office in Washington, D.C., and his first attorney in the D.C. case providing him discovery. Okay, so a mistake was made in the D.C. case, and the prosecuting attorneys, in disclosing what evidence they had against him in discovery, gave him a list of the officers who would be testifying against him, which they probably should not have done. But for the Washington, D.C. indictment, this case would never have been investigated, charged, and prosecuted. The cases are clearly related to one another. Sorta, kinda. The scope of Mr. Kelly's pardon and the executive order to the Department of Justice to dismiss all pending indictments against January 6th defendants with prejudice render this case no longer federally cognizable and ripe for dismissal on the grounds of lack of jurisdiction, an issue this court may address at any stage of the proceedings. The argument, of course, I would never have been plotting to murder any FBI agents for pressing a case against me had they not been pressing a case against me. So you see, I have to be like, oh, this is being, I don't think this is going to work. It's not supposed to work. but it is happening. And as long as it's happening, is it really any more or less crazy than, hey, man, I got a pardon? That means for everything. And, I don't think we're too far off from Trump claiming the power to pardon state charges. I know that has never been in any part of the interpretation of the pardon power under the Constitution as we've understood it to now, but that doesn't mean he can't claim it's true and force the courts to spend several weeks to several months actually debating whether or not it is true, even though most people were raised on the notion that it simply is not. But what if it just was? And what if we were all wrong? It's just so amazing. And it never ends with these guys. It never ends. You never know what you're going to be dealing with these weirdos. It's really pretty incredible. And I felt like I had to get it out there because this could really come back to haunt us at any time in the near future. Okay, we'll keep an eye on that case and see if it makes the news again in what would be, I'm sure, an extraordinarily bad way if we are to take notice of it again. Perhaps a good follow-up to those stories. This from Politico. What's the dateline here? Oh, okay. Very recent. Yesterday. For you. Actually, for me, too. This is yesterday for me, 2 days ago for you. 1/29/25, this story in Politico. DOJ moves to drop prosecutions of former Trump co-defendants in the classified documents case. The request offered no explanation for the Justice Department's decision to abandon the case against the two Trump allies, and that's because there's no good explanation for it. So rather than give a bad one, they just gave none. We're inching closer and closer, I guess, to that point where the Supreme Court, whether under pressure or just because they wanna, issues an opinion with no opinion in it. Just a ruling. We don't know why we ruled this way. We just did. Don't ask any questions. Josh Gerstein and Kyle Cheney, also on this piece here, the Justice Department on Wednesday moved to drop its effort to prosecute Donald Trump's former co-defendants in Special Counsel Jack Smith's classified documents case. Prosecutors asked a federal appeals court to dismiss an appeal filed during the Biden administration that sought to reinstate criminal charges against two men Smith had charged alongside Trump. And as I recall, and is this maybe Aileen Cannon? Yes, must have dismissed all of the cases, not just the one against Donald Trump, but dismissed the case against these two guys as well. And that was the subject of the appeal. The request from the interim U.S. attorney in Miami, Hayden O'Byrne, offered no explanation for the Justice Department's decision to abandon the case against the two Trump allies. They are, of course, Walt Nauta and Carlos de Oliveira. Nauta and de Oliveira are Trump aides who were accused of helping Trump obstruct the investigation into classified documents stored at Mar-a-Lago after Trump's first term. Smith charged them with obstructing justice and making false statements. If the appeals court grants the government's request, which is expected, it will bring to an end the last remnant of the federal criminal prosecutions against Trump. U.S. District Court Judge Aileen Cannon dismissed the case against all three men in July, agreeing with defense arguments that Smith had been illegally appointed. Remember that stupid argument? Under former Attorney General Merrick Garland, the Justice Department appealed Cannon's ruling to the 11th Circuit Court of Appeals in Atlanta, seeking to revive the case against all three defendants. But the part of the appeal that sought to reinstate the charges against Trump was dismissed in November at Smith's request after Trump won the presidential election. The special counsel cited longstanding DOJ policy against prosecuting a sitting president, even though he wasn't one in November. However, until Wednesday, the Justice Department had continued to press the appeal against Nauta and de Oliveira. And I don't know whether they get into it here or not, but one of the reasons would be because if they don't, then what gets left standing is Aileen Cannon's ridiculous ruling that the appointment of Jack Smith was unconstitutional. And so, even though they've also dismissed the January 6th case, the whole thing goes away and it never happened. And there is no such thing as a special counsel and there may never be one again, even though nobody else agrees with that. And it should be a relatively easy thing to get the 11th Circuit to say, well, at a minimum, we overrule the part of the decision which holds the appointment of Jack Smith to be unconstitutional. But now we won't even get that. Spokespeople for the Justice Department and for the U.S. Attorney's Office in Miami did not immediately respond to requests for comment on the move. Trump faced dozens of felony charges for allegedly retaining an extensive collection of national security secrets. And I mean, come on. He did keep them. All he was arguing was that he should have been allowed to. There's no allegation that he retained these things. We all saw them get carried out of his house. Anyway, Trump faced the dozens of felony charges for allegedly retaining an extensive collection of national security secrets and then seeking to conceal them after the government officials sought their return. Nauta and de Oliveira were charged with aiding Trump's alleged scheme to obstruct the Justice Department's efforts to recover the documents. The dismissal of the appeal is likely to renew calls to make Smith's final report on the classified documents matter public. Garland declined to release the report because of the effort to continue prosecuting Nauta and de Oliveira. Cannon blocked Garland from sharing the report with Congress. Democrats are likely to ramp up their demands to review the report. The Justice Department's move is also likely to accelerate looming court battles over whether the report will be made public. That's the end of the article. And I guess if I had to think this through, I wouldn't be surprised to see the Trump Justice Department continue to oppose the release of the report. And I mean, why not? Right? If no appeal is allowed to be brought of Aileen Cannon's ruling that Jack Smith's appointment was unconstitutional, it would then, therefore, I assume, be, in their view, unconstitutional to release the report. It was written by someone who had no constitutional authority to write it, according to Aileen Cannon, probably not according to the 11th Circuit Court of Appeals, probably not according to the Supreme Court, but no one has asked them because the case has been dismissed. The case is just dropped with no explanation by the so-called Justice Department for no particular reason. Please don't ask. Wow. Brendan Nyhan, of course, commenting on this. This is how it came to my attention, this story, this version of the story, commenting on Blue Sky. To be clear, this is a breach of DOJ independence. It says the breach, but a breach will do just as well here. DOJ had a policy, as you know, against prosecuting a sitting president, so they dropped the case against Trump on their own. But now Trump is now the president and has named an acting U.S. attorney who dropped this case against his associates. So this is a real interesting situation, right? Trump stole the documents and he enlisted Nauta and de Oliveira to help hide the documents and to obstruct the investigation that would otherwise have held him accountable for having stolen the documents. But then he won the presidency and used that power to dismiss the case that would have proven that Trump enlisted these guys to obscure the facts of his having stolen the documents. So this is really, this is kind of directly addressed actually in the Federalists, right? When they talk about what's an impeachable offense, among other things. As I recall, they describe very clearly, well, you would have to impeach a president who enlists the aid of others to cover up the commission of his own crimes. Anyway, just thought that was an interesting follow-up to the pardons situation. And I assume that eventually, in addition to dismissing this case, I don't know, maybe he doesn't really feel like he needs to issue a pardon for Nauta or de Oliveira because now there's no case against them and no foreseeable case anytime in the future. In oligarchic news today, we got this from the Wall Street Journal, which I apparently have full access to. In this particular case, I must have gotten a gift link for this article. But Zuckerberg, I guess, joining the ranks of those knuckling under still further beyond the $1 million contribution for the inauguration that Trump pocketed. Now joining ABC News, which I think offered $15 million by way of settlement to Donald Trump when he filed a frivolous lawsuit against them. But I guess he sicked, remember this one? He sicked his FCC people on him and saying, maybe you won't get your broadcast license renewed if you still are not paying up for the lawsuit I filed against you. Was it ABC or was it CBS? ABC agreed to do it, right? Because of the George Stephanopoulos interview or report in which he correctly stated that the judge in the New York lawsuit, the E. Jean Carroll lawsuit, had said that Trump was being held liable for an assault that was tantamount to rape against E. Jean Carroll. And Trump filed a probably pretty easily winnable lawsuit for ABC against them. But they decided, well, we don't want to have our license endangered. Let's settle this issue. And then there was also a lawsuit against CBS. And I'm not sure whether they offered to settle that one or not. But this time suing CBS allegedly because he claimed that they edited the 60 Minutes episodes, both an interview, I think, with him and an interview with Kamala Harris, that they edited it in a way that was unfavorable to him and favorable to her. And so therefore something lawsuit. And well, basically Trump has stumbled onto a way to just simply demand tribute in dollars from, public companies in this country. And, to file frivolous lawsuits that ordinarily would be defeated easily, but instead threaten to force, I guess, maybe the Department of Justice. I don't know. I don't know whether the Department of Justice was pressing any of these cases. These are private lawsuits. I don't think so. But basically using his leverage and power as president to say things could go very badly for you if you don't settle this lawsuit. And if the companies just say, we hereby attest to our perfectly honest willingness to pay Donald Trump personally $15 million, there's not that much that any court is likely to do about it. It might just be, that's it. You've hit upon the most legal bribery scheme that we could think of. And Mark Zuckerberg now wants in. Meta, anyway, is the one that's going to be doing the paying here. So I guess it doesn't bother Zuckerberg all that much. Meta to pay $25 million. They're upping the ABC offer by $10 million to settle 2021 Trump lawsuit. And by the way, you should keep in mind that this lawsuit was filed, as I recall, in close proximity to, maybe after Donald Trump threatened to, if he were returned to the presidency, to throw Mark Zuckerberg in jail for life because of this horrible treatment that he had given me. And what it boils down to is, after the Capitol riot, Meta, along with some other online social media outlets, banned President Trump's, did they wait until after the 20th and January 20th, 2021, former President Donald Trump's banning Trump's account from Facebook, Meta. And that's horrible. And I'm going to sue you. And you would absolutely positively lose that lawsuit. Meta can ban anybody it wants. It's a private organization, but can't ban the president anymore without bad things possibly happening to you. So here we are. Meta to pay $25 million to settle a 2021 Trump lawsuit. President had sued social media company, this Wall Street Journal subheader says, after his accounts were suspended following the January 6th riot. Annie Linsky and Rebecca Bauhaus have put this piece together. Get to it. Meta Platforms, that's what Facebook calls itself now, has agreed to pay roughly $25 million to settle a 2021 lawsuit that President Trump brought against the company and its CEO after the social media platform suspended his accounts following the attack on the U.S. Capitol that year, according to people familiar with the agreement. Of that $25 $22 million will go toward a fund for Trump's presidential library, with the rest going to legal fees and other plaintiffs who signed on to the case. Meta won't admit wrongdoing, the people said. Trump signed the settlement agreement Wednesday in the Oval Office because it was an official act. It was not an official act. He shouldn't have been doing that, but whatever. And it's not for me. It's for my presidential library, which I understand there was some information. He is scouting out locations, and I guess Florida International University, FIU, just FU for short, Florida International University might be the location for it. And I think the officials there, I don't know whether it was the president of FIU or whatever, had commented, and they were noting that he's apparently a Democrat, saying, well, we're looking to do it like, who wouldn't want this, right? And one part of the reason who wouldn't want it is it comes with millions and millions of dollars to construct the thing. So maybe that's of benefit to the university. I don't know. Anyway, a Meta spokesman confirmed the settlement. It looks like a bribe and a signal to every company. This isn't their settlement. This is the Meta guys. We moved on to Senator Warren here. No warning really, but you can tell that the tenor of the comments is such that it's not the Meta spokesman confirming the settlement. It looks like a bribe and a signal to every company that corruption is the name of the game, Senator Elizabeth Warren said in a statement. She's quite right about that. After Meta pays to play, what does Mark Zuckerberg expect as a return on this investment? That's actually a tough question. I don't know that Mark Zuckerberg expects a return on investment, other than not getting persecuted further or thrown in jail for life, as was the threat, you may recall. Or maybe he thinks that Trump will be open to allowing him to be a powerful oligarch in the upcoming years of the administration. Serious talks about the suit, which had seen little activity since the fall of 2023, began after Zuckerberg, Meta's chief executive, flew to Trump's Mar-a-Lago club in Florida to dine with him in November. It's always dining, of course, with this guy. Gotta have a meal. According to people familiar with the discussions, the dinner was one of several efforts by Zuckerberg and Meta to soften the relationship with Trump and the incoming administration. Meta also donated $1 million to Trump's inaugural fund. Last year, Trump warned that Zuckerberg could go to prison if he tried to rig the election against him. Well, he didn't. So, whatever. That's actually, I don't know. That's the threat he made. Could go to prison. I'll throw him in prison for the rest of his life. Toward the end of the November dinner, why go to the dinner at all with people who say they're going to throw you in jail? Trump raised the matter of the lawsuit, right at the effing dinner. No subtlety whatsoever. The president signaled that the litigation had to be resolved before dessert. Before Zuckerberg could be brought into the tent, one of the people said. And cut into pieces with a bone saw. Weeks later, in early January, Zuckerberg returned to Mar-a-Lago for a full day of mediation. Trump was present for part of the session, though he stepped out at one point to be sentenced, appearing virtually for covering up hush money paid to a porn star, one of the people said. Well, we didn't have to rely on one of the people to find out what that was about. But how interesting is that? Well, excuse me from this bribery meeting. I have to go get sentenced for bribery. What are we doing? Boo-hoo. I know, I'm laughing, but holy cow. He also, of course, golfed, right? I've come to lick your boots. I've come to supplicate myself and to ask, how much money do you want me to bribe you with? I'll be right back. I want to play golf. Talk to my people about this. He also golfed, reappearing in golf clothes and talking about the round he had just played, the person said, so he has to, negotiate with the stinky, sweaty guy. Trump has long been a prolific filer of lawsuits, with mixed results. In recent weeks, that has changed, as U.S. corporations have rushed to make inroads with the new administration. ABC News in December settled a defamation lawsuit Trump had filed against the network and the anchor George Stephanopoulos, agreeing to pay $15 million to Trump's library. So now he's got $37 million already raised for it, just from lawsuits. 2 lawsuits. Paramount Global executives have discussed settling a lawsuit that Trump filed over a CBS News interview with then Vice President Kamala Harris. He wasn't even in that one. Trump's lawyers are working to capitalize on that momentum. I'm sure they are. Contingency fees for nothing. In December, a lawyer for Trump filed a letter in an unrelated case in which the president had sued the publisher Simon & Schuster and the author Bob Woodward over publishing recordings of their interviews without permission, urging the defendants to follow ABC's lead. Attaching a copy of the ABC settlement, the lawyer wrote, why? This should be, confidential between the two of you. President Trump is hopeful that the defendants in this case follow Mr. Stephanopoulos' expression of contrition. The Meta lawsuit was one of a series of legal actions that Trump, freshly voted out of office, brought in July of 2021 against social media companies that had suspended his accounts. He also sued Twitter, now, of course, renamed X, and YouTube, along with their corporate leaders. A federal judge dismissed the Twitter suit, and the Google suit was administratively closed in 2023 but could be reopened. John P. Cole, like C-O-A-L-E, a Trump backer who represented Trump on the Meta suit, which was without merit, but suddenly is a winner, first discussed the idea of suing the big tech companies at a 2021 meeting with Trump. It was a period in which Trump was politically at his lowest, out of power, having been impeached for the second time and facing prosecutions that he and his allies viewed as lawfare. He has incoming, nothing but incoming, said Cole. I said to him, we've got to have some outgoing. We've got to attack. Cole said Trump remained highly engaged with the lawsuits over the years, asking for updates and providing input at crucial moments. He, along with the attorney John Q. Kelly, no relation to John Q. Public, embarked on years of litigation. At first, it didn't seem as if the lawsuits would yield much, mostly because there was no basis for them, of course. Censorship runs rampant, the 2021 complaint against Meta read, and the result is a chilling effect cast over our nation's pressing political, medical, social, and cultural discussions. Trump and other plaintiffs who signed on sought an injunction ordering Facebook to reinstate their accounts and remove all warning labels from their content. So there would be some COVID truthers in there as well, anti-vaxxers, who knows what else. Trump's Facebook and Instagram accounts were suspended in 2021 because of posts he made around January 6th, 2021, when a mob stormed the Capitol building. I don't know why it happened at the same time as Trump telling them to do it, but that's what happened. In the days leading up to the attack and on January 6th, he repeatedly used the platforms to make false claims that he won the 2020 election and alleged widespread election fraud that was denied by the administration's top election security experts and attorneys. Zuckerberg at the time said the risks of the president's using the social media platforms during that period are simply too great, and then paused the president's accounts for 2 weeks. The pause was subsequently lengthened. YouTube, owned by Google, and Twitter also removed Trump from their platforms in response to posts he made around the time of the attack at the Capitol. Twitter said that its decision was permanent, though Trump was allowed back on the platform in November of 2022, shortly after Elon Musk purchased the company. YouTube lifted its suspension on Trump's account in March of 2023. How a lawsuit Trump filed nearly 4 years ago that faced slim chances of success turned into a $25 million settlement in the president's favor is partly thanks to efforts by Trump's lawyers to draw out the matter, even after a similar case was dismissed. In May of 2022, a federal judge dismissed the lawsuit Trump had brought against Twitter and its CEO at the time that the suit was filed, Jack Dorsey, rejecting Trump's argument that the platform had violated his right to free speech on the grounds that the clause only applies to the government, not private companies. That is to say, this was a total winner for all of these other defendants too. But Trump appealed that case, but the appeals court hadn't yet issued a ruling. 3 months later, a federal judge stayed the Facebook case, pending the disposition of Trump's appeal in the Twitter case. And it looked as if the lawsuit could peter out. But about a year later, Trump's lawyers revived the suit, requesting that the judge lift the stay and allow them to file a second amended complaint. In a conference with Meta lawyers on November 2023, Trump's lawyers argued that new information had come to light and said they wanted to pursue filing another amended complaint. Kelly, the lawyer for Trump, said that in that conference that while Trump's Facebook account had been restored, a chilling effect remained. Once you're censored, and that's it. But when you're restored, you have to watch your step, he said. You're sort of whistling in the dark every time you use Facebook and even approach matters that Facebook is not endeared to, such as our ex-president. Ugh, what a clunky statement. U.S. District Judge William Alsup indicated that he was dubious about the argument. Dubious of the argument is what it should say. He's not dubious, but okay. Dubious of the argument. Is it really plausible that President Trump, who is as vigorous a person as could possibly exist, is afraid of his shadow and will be chilled in what he says on the platform? He said, I rather doubt it, especially as he had a platform of his own by that point. In March of last year, Trump's lawyers said they were waiting for a decision in another related case before filing their amended complaint. They hadn't yet done so by November when Zuckerberg arrived in Palm Beach, Florida to meet with the president-elect. So, what can I tell you? Kind of a genius move, dragging things out long enough so that until it finally becomes obvious that he's going to bring down the hammer of government on you unless you settle this ridiculous suit. So you just do it in the hopes to stay out of the crosshairs. It's really pretty remarkable, to say the least. All right. So that's it for, I think, oligarchic news. And we could turn our attention back to the drama surrounding both the O memos, the OMB memo purportedly freezing all of the spending, the OPM memo purporting to offer people buyouts from their positions in the government. Let's see. Why don't I start? I'll take you back to the Federal News Network, which is the pretty neutral, very staid Washington source connected to WTOP, the all news station here that does, everything it can to walk a middle path on stuff. But when they're focusing on issues of the federal government, they really have their audience in mind. That is to say, the federal workers and the families of federal workers in the Washington, D.C. area. I mean, it's an enormous audience. It means an awful lot to them. So they have a tremendous interest in giving, in upholding their reputation for giving good, straight, solid advice on this stuff. In this case, they are running a story by Jory Heckman, an exclusive to the Federal News Network. Survey, what's the survey say? Survey says, bing, most feds say OPM's resignation offer too uncertain to accept. That's a very gentle way of saying it. But again, that's supposed to be the middle of the road. It's too uncertain to accept. Most survey respondents who say they'll take OPM's deal already had plans to retire from the federal service soon or to leave the job for a job outside of government. So what's going on here? A significant majority of the federal employees who took a Federal News Network survey say they don't plan on accepting the Office of Personnel Management's offer to resign and go on unpaid administrative leave. You may recall, we may have mentioned somewhere along the line that the nearest to accurate interpretation of the offer so far, it would be a misnomer to say that it was a buyout. Instead, it was an offer to allow people to continue working up to September, I guess the end of the fiscal year, and to do so in their current remote or mostly remote work situation if they wanted to. In other words, to exempt themselves from the return to office orders, but with the expectation that they would resign from their job by September. That's not a buyout. That's a, You want to keep working until we fire you? Cool. That's fine. In a survey of 4,619 federal employees, more than 3/4 of respondents said they didn't intend to accept the deal that OPM sent. Maybe OPM sent it. Somebody did. They spoofed the server and sent to most civil federal workers in a mass email Tuesday afternoon. I want to be employed as a federal civilian as long as possible, one respondent said. And this is kind of a key point here. I don't know. I imagine most critics of the nameless, faceless bureaucrats in the various departments don't know this about federal employees. But if you ask them to describe the road to getting the job that they've taken, I think most people think the faceless bureaucrats just took some job, whether it was flipping burgers or working at the Department of, you name it, education, agriculture, transportation. They just are paper pushers in the job for the paycheck and possibly the job security and not much more. But yeah, talk to federal workers about it and they'll tell you this story. I worked too hard to get into the federal government to give it away. I love my job and what I do for America. There's a great, a great point of pride in this for a lot of people. It's not just some job. I mean, it seems like it perhaps to people who think that bureaucratic work would somehow be drudgery, but they're pleased to be spending their days actually doing the work of the United States government and making things happen and running programs that help people. And they take it seriously. On top of which, it's not easy to just, walk into a federal job. The application process, as I understand it, is actually pretty thorough and rigorous because they're trying to make sure that they, one, aren't hiring people that are going to be an embarrassment to them in any way, and two, are going to take the job very seriously. And it's not a matter of, like with most jobs, you see an ad in the paper, you go in, you interview with the boss, and the boss makes a decision, hire or not. You got all sorts of layers of bureaucracy to go through, all sorts of forms to fill out. It's actually something of a nightmare, and it's well described here. I worked too hard to get in there, and that people do that work because, yes, there is job security. It's not often great pay, but there's pretty good job security and pretty good benefits. It's something worth spending the time to pursue. And then when you get it, you don't want to let it go. Employees who choose to resign will have to let OPM know their decision by February 6th, allegedly, if it was even OPM that asked, by replying to its email with the word resign, which really doesn't seem like a smart idea. In a survey of those 4,619 federal employees, more than 3/4 of respondents said that they don't intend to accept the deal. Why is it? This seems mostly like a repeat, but it's not. Not the whole paragraph anyway. According to OPM's email, employees would be placed on paid administrative leave until the effective date of their resignation, which OPM said should be no later than September 30th. Again, that's the end of the fiscal year. Quote, I understand my employing agency will likely make adjustments in response to my resignation, including moving, eliminating, consolidating, reassigning my position and tasks, reducing my official duties, and or placing me on paid administrative leave until my resignation date, the email states. The email advises federal employees that the Trump administration may also pursue involuntary layoffs. At this time, we cannot give you full assurance regarding the certainty of your position or agency, but should your position be eliminated, you will be treated with dignity and will be afforded the protections in place for such positions. More than 500 respondents, about 11% of those who took the poll, said they intend to accept the deal. Among those who accept the offer, 54% said they already had plans to retire from federal service soon or leave for a job outside the federal workforce. After the election, I began to think about a VSIP or VERA. I'm not even certain what they are, but readers of the Federal News Service will know. One respondent wrote, referring to the federal government's authority to offer buyouts and early retirement offers. The proposal by the Trump administration pays better than these other plans. And that's one of the problems. That's part of the reason that experts in federal employment law say Yeah, I don't know if they're actually going to give you the thing they say they're promising you. It might not be legal for them to do so. So I wouldn't bet on it. Several respondents said they intended to take the offer after President Donald Trump signed an executive order on his first day in office calling on federal employees to return to the office full time. We have established ourselves as being very efficient at working remote, and that is arbitrarily being taken from us, one respondent said. We are being asked to return to the office to then get on virtual meetings because we are so geographically dispersed. Pointless. Probably true, but again, if you're looking for a technocratic response to this, it won't help. Others felt inclined to accept OPM's deal after Trump signed an executive order to reclassify tens of thousands of federal positions and make it easier to fire career employees who hold them. The executive order essentially revives the Schedule F executive order that Trump signed late in his first term but did not implement. With the upcoming reclassification of so many positions, my job security became precarious at best. Definitely causes one to consider other employment options before there are none, one respondent said. Other federal employees plan on accepting OPM's deal but don't intend on leaving federal service for good. Federal vacation until I start reapplying for federal jobs after September 30th, one respondent wrote. There, I guess, I hope the responses are anonymous, but then they'll end up subpoenaing, the Trump Justice Department will now subpoena to get the name of that respondent and target them for not rehiring. That's the sort of thing they'd be likely to do with this. In a frequently asked questions page on its website, OPM said accepting the deal, quote, does not affect your ability to apply to work for the federal government in the future. About 70% of respondents said they don't have enough information from OPM to make their decision either way. Many said OPM hasn't provided enough of the details on what accepting the deal would mean for their health and life insurance plans or whether it would impact their pensions. Another thing that's very important to them. I think giving us only a week to make this life-altering change is completely ridiculous. Everything is so vague and or confusing. I reached out to my HR, and they are clueless, because there's no real plan, of course. One respondent said, we need more time to make definite plans and really figure out what is needed when you retire. Others said it's unclear whether the federal government has the legal authority to make such an offer. OPM, in the final days of the Biden administration, finalized guidance to comply with the 2016 Administrative Leave Act, capping how long federal employees can remain on administrative investigative leave to 10 days per year. By law, agencies can only offer buyouts of up to $25,000. So there's two good reasons to believe that that's not going to happen. One, we don't know if this is legal. Two, there's no money for that in the budget, Senator Mark Warner told reporters in a call on Wednesday. What I'm afraid of is anybody that says, well, I'm going to take the offer, and then you end up with the offer not being honored. You got a big target on your back in terms of RIFs, he added, referring to involuntary reductions in force. OPM's ultimatum, Warner said, may also disproportionately hollow out certain agencies. If another couple thousand air traffic controllers say, fine, I'm going to take the money and not work for the next 6 months, we'll have an air traffic emergency, he said. And time out. Let me just point out to you that he is quoted in this article, which went to publication January 29th, 6:49 p.m. All right. 2 hours later, there was such an air emergency. And that's why Mark Warner was all over the television yesterday, not just because the airport is, well, technically in Virginia, although it has, for some reason, a Washington, D.C. zip code. They want to think of it as part of Washington, D.C., but it sits in Virginia, damn it. And obviously, he's heavily involved in the airport operations there. I thought that was kind of interesting. I had to zip back to see what the time of publication was. How amazing is that? I mean, I guess he gave that quote a couple hours ahead of publication time, but imagine getting that quote and then, you know, that evening you see that there is an air disaster after all. Okay, where did I leave off here? Okay. So that's some quote. If another couple thousand air traffic controllers say, fine, I'm going to take the money and not work, we'll have an air traffic emergency. Hours later, we did. Not because people took the buyout, but just saying. Survey respondents said they're concerned OPM's offers will have a disproportionate impact on their agencies or their program offices. Several respondents raised concerns specifically about the Department of Veterans Affairs. While OPM's email states agencies can exclude certain positions from the offer, who knows which ones, the Federal News Network heard from several frontline VA healthcare workers who have received OPM's offer, but have received no word from their supervisors whether they are exempt. Federal News Network has reached out to the VA for comment, but they don't know what to say, I'm sure. I have concerns that the veterans receiving healthcare through the VA healthcare system will be greatly impacted if many clinicians, nursing staff, and the support staff choose to take the deferred resignation. One respondent said, I'm concerned for those of us who choose to stay and how we will complete the added workload due to vacant positions. I think this is an example of shooting first and asking questions later. Some respondents said they're not sure what impact the government shutdown would have on this offer. Government shutdown. This is an unofficial government shutdown right here, right now, but we're talking about the one that's coming in, 6 weeks, 40-something days? Yes. Some respondents are said they're not sure what impact the government shutdown, the actual one that's still looming, will have on this offer. Congress passed a continuing resolution that will keep the federal government funded through March 14th. What's keeping me from answering a firm yes to this question is that I have concerns about whether they can or will make good on the offer. That doesn't even actually reflect this, but maybe it came on the same form or something. But yeah, good point. March 14th, the government shuts down. Whether they restart or not, we can't tell what kind of impact that's going to have on a deal that the government may never have had the authority to offer to anyone in the first place. But if I had to guess, I'd say, yeah, you're out of luck. Sorry, you resigned, and what can I say? You're kind of dumb for doing that. Whoops. Oh, well. Man, well, that's a real possibility. All right, I have a couple of other articles related to this subject, which are parked around the same place here. If we can speed up the process a little bit here, Mr. Computer, so that we can get to the neighboring articles. No, you got to think about it a little while longer. All right, let's try reloading Pocket and see if that'll work any better. Okay, here we go. So, yes, Politico tried to help figure out what the events of the previous day were with respect to that memo, which they ended up rescinding. But they didn't rescind it because they were rescinding the policy. This is a very interesting play. And I think it's described in this article. But there was a lot of pressure during the press availability for, what's-her-name, Carolyn Leavitt, and she just wasn't sure what the answers to any of the questions were about who's exempt and who's not, and whether or not it would mean turning off Social Security and Medicaid payments. They tried to claim that it wouldn't, but I'll have to check on that. 70 million people left in the dark, whatever, who cares? And then eventually they rescinded the memo, but in a truly Trumpian ploy here, they rescinded the memo and then told courts where lawsuits had already been filed against the administration, challenging its authority to freeze spending. We're over on the OMB memo now, the memo freezing spending. So everybody who's a beneficiary of the spending was in court suing, and the play here was that the Trump administration would say, well, you can't sue us because the basis of the suit was a memo that we have since rescinded. So dismiss everything. Although, people are rightly pointing out, well, you've rescinded the memo, but they're smart enough to know that in Trump's brain, you can separate the two. Now, for normal people, if you rescind the memo, that's a rescission of the policy. But Trump can say, no, all I did was rescind the written part of it. The idea is still there, and I'm still using it. That's the policy. I just didn't write it down, is how I want you to regard this. Is that a plausible thing? Maybe in Amarillo, but I don't know about anywhere else. Anyway, this Politico article actually kind of takes a look at how they fared with all of this, but along the way tells the story of what happened. Trump went for shock and awe. Now he's mopping up. There was widespread concern even before the White House walked its plans back. But then what does it mean to walk them back at all? Lisa Kaczynski and Liz Crampton have the byline for this, again, for Politico. It didn't take long for Donald Trump's second White House to end up in cleanup mode. Trump's budget office has rescinded an order proposing a freeze on large swaths of federal aid, capping off a whirlwind a whole 48 hours, in which the president's push to rein in spending sowed chaos, of course, that was his idea, across levels of government that administration officials were left scrambling to contain. The White House officials had already issued a flurry of statements and memos on Tuesday attempting to clarify which assistance programs would be affected amid outcry over potential disruptions to public health care benefits and other services for the elderly and low-income people. Concern was coming in from all corners, even before the White House walked its plans back, even as they broadly backed his attempt to scrutinize government spending. Some of Trump's allies on the Hill said they planned to press the president for more details on his proposed funding pauses. Republican governors similarly pushed the administration for clarity amid concerns the freeze could interrupt critical services in their states and jeopardize financial stability. Wow, not that. It culminated Wednesday afternoon, Washington Wednesday, and this Washington Wednesday afternoon, in the White House yanking the memo from the table, a reaction, in their words, to a judge's order on Tuesday blocking the freeze and media coverage, but a seemingly tacit acknowledgement that there may be limits to the president's shock and awe strategy. The broad backlash to Trump's plan, the first example that the president isn't invincible in pushing through his broad agenda, offered a potential preview of the level of blowback Republicans could face if they pursue deep spending cuts to fund the president's sweeping policy agenda, which is mostly tax cuts for the rich, of course. It also showcases the difficult spot Trump places Republicans in as he pursues a slash and burn approach to governing that could have far-reaching negative effects, on their constituencies back home. Democrats who have struggled to land on a unified message against Trump pounced on the order as their best opportunity yet to cast his second presidency as chaotic and harmful to everyday Americans. But they didn't get to fully seize on it. The reversal was revealed just as House Democrats were joining a virtual emergency caucus meeting to discuss the initial action clawing back federal spending, a meeting announced a full day prior. Donald Trump's reckless and unlawful decision to freeze nearly all domestic federal funding wreaked havoc yesterday, said Representative Jerry Nadler on X. Now that Trump has rescinded this order following a federal judge's stay, I urge him to stop issuing half-baked, disastrous policies that harm American families. All right, well, as long as you're urging him. Senator Patty Murray, Democrats' top Senate appropriator, told reporters at Capitol Hill on Wednesday afternoon that she would take the Trump administration's walk back, quote, as a victory for now that they listened to the American people, but remained concerned that, quote, we're still holding billions of dollars in a freeze. Rubio was the first cabinet official on Tuesday to begin to backtrack on Trump's wide-ranging stoppage of government spending by exempting life-saving humanitarian assistance from an earlier pause in foreign aid. Rubio's carve-outs include medicine, medical services, food, shelter, and other crucial forms of support. He said in a memo, first reported by the Washington Post, Trump's initial order stopping all foreign aid left many humanitarian groups confounded. And now it's, we'll exempt, food and medicine and, other crucial forms of support. What would they be? Anything I decide. The fallout and the cleanup only grew from there. The confusion over the domestic freeze spilled out far beyond Washington as trillions of federal dollars were suddenly jeopardized, propelling a blistering news cycle detailing all the ways the pause in spending would impact many facets of American life. on Tuesday. And by the way, if you are one of those people, you're not listening to the show if you are, but if you're one of those people who think, government shutdown, who cares? Government doesn't affect my life at all. Well, you just watched a government shutdown in everything but name happen, and the big panic was, oh my God, it's going to affect my life. Believe me, government shutdowns will affect your life. On Tuesday, some state health departments were reporting that they can no longer access the online Medicaid portal used to process payments and reimbursements. A hiccup that providers said threatened health insurance for more than 72 million Americans. And nonprofits that rely on federal assistance were fearful that their operations could no longer continue, like Meals on Wheels, which supplies meals to millions of seniors, and Head Start, which gives preschool funding to low-income children. Questions over the reach of the freeze dominated White House Press Secretary Caroline Leavitt's first briefing on Tuesday afternoon. She insisted that the pause would not directly affect assistance that goes directly to individuals and was intended to target parts of the government that conflict with Trump's agenda. The White House later blamed an outage for locking out the online Medicaid system and also released a fact sheet attempting to explain the contours of the president's action. Senior White House aide Stephen Miller appeared on CNN that afternoon and continued to pile blame on the media, arguing with host Jake Tapper that the order did not apply across the board and instead was intended to eradicate wokeness from the federal government. Oh, yeah, very specific in that. It all accumulated in a federal judge temporarily blocking the order just minutes before it was set to go into effect on Tuesday. That judge's order remains in effect through February 3rd. On Wednesday, another federal judge signaled that he will block the freeze, despite the White House walking back its hugely ambitious order. The White House, in a statement, said the reversal was intended to end confusion caused by the court ruling and dishonest media coverage. But the two-line memo rescinding the initial order did not end the confusion. What do you know? On X, White House Press Secretary Caroline Leavitt said that the latest memo was not a rescission of the federal funding freeze, and instead simply a rescission of the OMB memo. How do you like that? We're rescinding the memo that had the policy in it, but not the policy. Isn't that astonishing? She added that Trump's executive order on funding remains in full force and effect and will be rigorously implemented. A Trump spokesperson denied that the funding had been rescinded, repeating what Leavitt said that the guidance memo was pulled back and the executive orders remain in place. Still, some of the GOP believe the spigot was turned back on and acknowledged the intense public reaction. I'm grateful to all the Pennsylvanians who reached out about the administration's spending pause over the last 24 hours, said Senator Dave McCormick on X. The pause has been rescinded. Your input made a difference. Thank you. Well, no, it hasn't, but go ahead and operate as if it has been if the money is going to go to friends. And if the money was supposed to go to enemies, well, you can just deny that the whole thing happened, I guess. Wow. Pretty amazing. And not the last of what I have parked here for you. I have information also from Just Security, which I think we parked here yesterday. And I thought I had, and probably will still need to rediscover here, something from Judd Legum on the subject. But here, I offer you this from Just Security, which tends to get a little weedy about these things. If you want the technocratic explanation for why this friend-enemy declaration isn't supposed to work, Suzanne Summerlin has got it. On Tuesday, the Office of Personnel Management released a memorandum detailing the outlines of the deferred resignation program. And I know these two memos are blurring together. They are somewhat related, but they, of course, come from different places, if they, in fact, came from the places that they purport to come from. That's one of the problems both of these things have. According to OPM, the program allows federal employees to submit their resignations by February 7th with an effective date of September 30th. You know those details. OPM says employees who opt for this arrangement will remain on payroll and continue receiving their full salary and benefits until their resignation becomes effective. The memorandum also states that agencies may place employees on administrative leave or adjust workloads, but it doesn't guarantee these conditions. Some initial reports suggested that this offer includes voluntary separation incentive payments. That's the VSIP, commonly known as buyouts. However, there is no mention of such payments in the actual OPM memorandum regarding the deferred resignation. Employees who resign under this offer should not expect any severance or incentive beyond continued employment until September. So no extra money, no upfront money. It's not a buyout in any sense. That's just an assumption that you made because that's the only context in which leaving the job or resigning now makes any sense as a buyout. So they constructed this thing in their own minds to try to make sense of a memo that makes no sense. Despite OPM's framing, the legal authority for such arrangement remains unclear, raising significant concerns about potential violations of federal employment law, unwise public policy, and budgetary constraints. What do you know? Well, this does get a little bit weedier than I think we could all tolerate, but I recommend it to you for weekend reading if you want. I mean, this is where this goes. The next section is unclear legal basis for administrative leave. We knew that, but here are the particulars. OPM suggests that employees who opt for deferred resignation may be placed on paid administrative leave during this period. This raises questions, because it's just a may, I guess, under 5 U.S. Code Section 6329A, the Administrative Leave Act, which limits the use of administrative leave to 10 days total, right? So you can't say, well, I'll take administrative leave until September. That's not a possibility. The OPM memo appears to say that it is a possibility, and I don't know whether you're one of those people that believes the Trump administration will just make it happen. Maybe. Or they'll say, oh, gosh, what do you know? Rule of law. Sorry. Here's your 10 days pay in September. The rest of the time you worked, I don't know what you're going to do about that. However, recent regulations promulgated by the Biden administration direct OPM to interpret the 10-day cap as applicable only to administrative leave for investigative purposes, like you are suspected of possibly having done something wrong. They put you on administrative leave to investigate. You get 10 days on that. If it's not to investigate you, it's just I'm planning on leaving, and so they're putting me on administrative leave. Nope, not even the 10 days, probably. Oh no. Well, that's 0 days. What do you think? 5 CFR, that's Code of Federal Regulations, Section 630.1404, in case you want to look it up. This interpretation may be enough to bring the deferred resignation policy into compliance with the Administrative Leave Act. Nevertheless, agencies would still need a valid legal justification for prolonging administrative leave, and it's not clear that the OPM's offer would be sufficient. Federal workers considering this choice should deeply consider that OPM's offer may be rescinded or overturned. After all, the memos from OMB were rescinded, even though the claim was the paper's gone, the policy remains. How do you deal with that? There is the next section here. Employees have a right to withdraw resignation. Okay. Well, what does that tell us? Under the Code of Federal Regulations, again, with the citation and everything, federal employees who submit resignations retain the right to withdraw them before the effective date, except under limited circumstances where an emergency can demonstrate, where an agency, it looks like emergency, but where an agency can demonstrate that withdrawal would be disruptive to operations. The Trump administration's plan seemingly acknowledges this right and says that employees who wish to withdraw their resignations at a later date could do so. However, there is nothing legally binding agencies to that promise. In fact, legal precedent establishes that agencies could easily deny an employee that wishes to withdraw their resignation so long as the agency has replaced the employee, abolished the position, or can prove operational disruption. If an employee accepts the deferred resignation, they may legally attempt to withdraw it at any time before September 30th. Agencies that deny these withdrawals without proper justification could face legal challenges, but then you could be ordered to lose by the DOJ, I guess. However, it is not advisable that workers rely on the administration's promise to honor the wishes of employees who elect to resign and then decide to stay. So you see, there's a lot of problems with this. The resignation acceptances are not guaranteed. It's bad public policy, they argue later on down here. Corporate strategy like this, when Elon Musk used this, remember we learned the other day, he used this exact same play at X. Corporate strategy, well, it's kind of ill-suited for government use, don't you think? How so? The federal government is not a corporation, and attempting to run it like a business disregards the statutory and regulatory framework that governs public employment. Unlike the private sector, federal employment is bound by strict legal protections and congressional oversight, making this kind of forced attrition legally and logistically impractical. So what should federal employees do? They should not rush into accepting this offer without consulting their union representatives or legal counsel. Federal sector unions and others have advised their members not to take the deal. The reality is that this offer provides little to no benefit for most employees. The only certain outcome of this plan is that employees who accept it will be signaling to their employer that they are willing to resign from federal service, with no promise of that resignation being accepted or of any compensation beyond what they would normally receive anyway. Given the clear conflicts with existing federal law, this policy is likely to face legal challenges, and those who sign on too quickly may find themselves locked into a disadvantageous position with no recourse. So again, before taking any action, consult with your union, seek legal advice, wait for further guidance. The conclusion here: an unsound and unstable proposal. The Trump administration's deferred resignation plan is fraught with practical and legal issues. It appears to be a policy designed to encourage federal employees to volunteer to resign under potentially misleading or unenforceable pretenses, offering nothing of substance in return. Generally speaking, federal employees should reject this offer. Otherwise, they risk walking away from their careers based on an unenforceable and potentially unlawful policy. An employee facing this decision would be well advised not to sign anything unless and until they have received personalized advice about their situation and feel completely prepared to assume any risks associated with this proposal. It's a new world for these people who are federal employees by choice and have come to rely on being able to take the word of the federal government as gospel, or at least have a very clearly delineated and enumerated set of rights, and that they can adjudicate under a, if not clear process, one that is familiar to them. Nothing's ever clear, of course, but they know exactly where they can go to file their grievances. And now, of course, the Trump administration has a very different idea of this. I'll tell you where to go to file your grievances, but you won't like it. It's actually pretty astonishing and a huge departure from the way they are used to doing business. Okay, well, unfortunately, I had a whole show planned over here, and there's so many more stories I wanted to share with you, and at least one or two more that I wanted to share with you today, and I've got the space for it, but we ran into a bit of a family emergency on Thursday as I was getting ready for this Friday show, and we had to skip town real quick. Everything's fine, but we had to run out the door a lot earlier than I thought and come back a lot later than I thought. So it's an hour and 40 minutes instead of the usual 2 hours today. But at least I was able to leave you with something fresh and new for the weekend. Of course, all of it will be obsolete by the time we return next week. But at least now I get to do a closing when it's actually Friday and say that we are, well, out of time. We're not really out of time, but we're leaving anyway. And that Greg will be back on Monday and we can discuss these things and more and whatever Donald Trump decides to blow up over the weekend. Man, I don't know. I don't know what to tell you. There's no sense in trying to predict anything at this point. But all right. And now we leave the task of filling in the extra 20 minutes or so to Justice Putnam, who will, I don't know whether we're going to follow up immediately with the West Coast Cookbook and Speakeasy, or whether there'll be some filler material until then. Probably that. Probably the latter. Anyway, we'll find out just like you on Well, you'll find out next, and we'll find out on Monday. Thanks for hanging in there with us.
NetworksRadio.com. You have been listening to Kagro in the Morning with David Waldman.
Man, I hope this weekend doesn't go too crazy. All right. Like I said, we got to wrap it up for today. So thanks for hanging in there. Thanks to everybody who's been sponsoring us on Patreon. I have no new sponsors besides the ones I thanked on Thursday. But I don't know. I had this time to spend with you until the show ends. Thanks a lot. We'll see you on Monday.